Time to bring in the think tank, and boy, do we have some brilliant legal minds tonight. Criminal defense attorney Ecleynne Mercy is here. Criminal defense attorney Joe Tamburino is here from Minnesota. We'll be talking a lot about George Floyd tonight. And one of our favorites, this guy graduated from Harvard Law at the age of 22, so we know he has a brilliant mind. Nima Rahmani, thank you all for joining us. Ecleynne, I want to start with you. This case, it is so gory, the details of what is alleged or what happened in this case. It's fact. We saw the video of the first responders today going in there. For a defendant of any ilk, if you're at the defense table and this is the crime, it's pretty hard to get over this hump. What's your take on of this case?
Why is there a trial? Why hasn't anybody just given him a plea deal? The issue is the facts are repugnant. They're abhorrent. It's I feel for the jury because I feel like everybody should get counseling afterwards. We're not privy to see the actual evidence, but they have to see the crime scenes. They have to see body parts that are real life in jars and a tub full of just craziness. It's insane. I don't know why they're having a trial. I would have accepted any plea at this point. You want to this is just disturbing.
We're going to play a little bit of the prosecution's opening, and when she talks about the situation in terms of the crime scene, and I want you to look closely at the defendant when the term diabolical stew is uttered by the prosecutor. It seems to me, take a look and get your opinion, it seems to me he is fighting back a laugh, like a chuckle. Take a look.
After the limbs of these people were removed, the killer placed them separately into two 45-gallon blue Sterlite containers. You will hear testimony and see evidence of where that took place, and you will learn that in the master bedroom of their home, plastic sheeting was placed on the floor, and these blue plastic bins were placed on the sheeting. The killer put Lisa's body parts in one, and he put Joel Sr.'s in the other. And then he covered them with a corrosive substance and left them there to liquefy into some sort of diabolical stew of human remains.
Joe Tamburini, I don't know what to say. What's your take?
It's crazy. I mean, this is like sort of a, Jeffrey Dahmer type of situation. I agree with Ecleynne. I don't know why they are having a trial. There's so many crazy things about this. Number one, they didn't go for the death penalty. Number two, you have pretty much an out of control client from the defense perspective, because basically a couple of days before jury selection, he's trying to get notes to the judge saying maybe I should get the death penalty. I don't know why they didn't raise an insanity defense if they're going to go through with this trial. So there's so many crazy things about it.
Yeah, Nima, the fact that not only do you have this evidence and you have him at the house, you have this diary of sorts, basically a checklist. It's almost his, like he's writing notes to himself about, what he's going to do, how he's going to do it. And then he actually writes out, all the money is mine. This does not seem to me like a whodunit.
No, this case is a layup for the prosecution, right? And it's interesting. This is one of the first trials that we're having post-COVID. You have a son who's killed his parents, but you have evidence of him buying the murder weapons, him going to the scene of the murder after the murder with chemicals that he's also bought, and, obviously cutting up the corpses and spreading them all over the house and liquefying some of them in chemicals, boiling others. And then you have this journal with all the admissions in the world. So I fully expect a guy to be convicted, to get a life sentence. I mean, I got to agree with Joe and Ecleynne. One of the few times I'm going to agree with my defense attorney colleagues. I don't know why this case is going to trial. clear life case. I expect the jury to return a quick guilty verdict on this one.
The motive here, financial, according to the state. One of the witnesses we heard from today was Michelle Tyler. She is the daughter of the father who was murdered, and she got pretty emotional on the stand.
They had both said, but Lisa said that Joel Michael was going to have to find a job because they only had a certain amount of money. The retirement, they had taken out his pension, and I'm not sure if that's the name of it, but they only had a certain amount to live on, and they would not be able to afford Joel Michael or paying for his apartment.
Okay.
Things like that.
And on Thanksgiving, what did your dad say to you?
You could, there was a little bit of tension, and so when everyone was inside and it was just...
I'm sorry? I'm sorry.
It was just me and Dad and myself. That was bad grammar. It was just me and Dad. We were out on the porch, and he said that Lisa hadn't told Joel Michael, and that you could feel like that was what was causing the little bit of tension inside the house. That you could feel the tension.
Okay.
It was a little bit.
Did he say anything specifically about them withdrawing financial support from your brother?
That's what he said. He had told Joel Michael about the that they had told Joel Michael about him having to get a job or being cut off, but he didn't. I can't remember his correct verbiage, but it wasn't cut off. It's that they couldn't afford to
Support him
any longer.
Okay.
Ecleynne, Mercy, a deal is all fine and dandy if both sides agree to it. Do you think it might be a case here where the state is not going to offer him anything except for taking the death penalty off the table, I would think? And if he, at the end of the day, says, no, I want to go to trial, I want to go through this, I want to be there with my headgear looking like Hannibal Lecter in front of everybody, there's not really much you can do, can you?
You can reset it and try to have a come to Jesus. Why are we having this trial? This is terrible. To put the victim's family through this, to put the jury through this, they have to see things. And then even a cursory, look at the case. Even the officers are still traumatized by the smell of what they smelled and the concoction that he put in the tub. This was bad. If I was a judge in this case, I would go back and think again and then come back, because I don't understand why we're here.
Yeah, well, I think the reason we're here is that guy there on our screen. We're going to step aside, take a break. When we come back, new filings in the George Floyd case. Stay with us. You're watching Court TV, your front row seat to justice.
His goal was to touch the world. That's something that he stated a couple of weeks before his death in a video, that he really, really wanted to touch the world. We had no idea that by him saying that, what happened was going to happen.
That is Bridget Floyd, the grieving sister of George Floyd. Court TV crime and justice reporter Julia Janae is here, and she has the latest in some criminal filings, or some filings in the criminal case against the 4 officers accused in Floyd's death. And Julia, let's go through them one by one. We'll bring the think tank in to have them opine about each one of these as we go through it. Starting with Officer Tutau, some revelations of how the prosecution's going to attack him.
Right, the state filing a amended notice of intent to file or intent to bring in certain evidence, and it includes the background of Officer Tutau. They essentially are saying that he has a history on the job of being lazy and avoiding work, and they list half a dozen or more incidents. We pulled out about 3 of them, including one in April of 2012, where they say he was sitting in the car while others worked, while there was an investigation going on, and he never got out of the car to join the other officers who were working. Then in June of 2012, they say that he was responding to a burglary call, and he was supposed to canvass the area for that burglar. He put that in a report, but did not actually do that. Turns out he stayed in the car that time too. And in a lot of these incidents, he was either reprimanded or had to have a discussion with his supervisor. Then in August of 2017, they say when he was investigating a domestic assault and interviewing a witness that he used his words to manipulate that victim into not filing a report. So they say that this points to his intent when he was actually involved in that arrest of George Floyd, and that it shows what kind of pattern his behavior was that day. And they bring up something that happened that was caught on body camera footage, and it's during a discussion between those officers about whether or not to put George Floyd into a different restraint. Listen to what Officer Tao says at the very end of that discussion.
You got your restraint? Hobble? Okay.
I can't breathe.
I'll grab that. Once we get him.
I can't breathe. I can't breathe.
Thank you.
I can't breathe.
Stop moving.
Mama. Mama.
Yeah,
Mama.
it's in the,
Mama.
one of the front pouches
Mama.
on my right side bag.
Mama. Mama.
You're on the rest guy.
All right. All right. Oh my God.
Are we calling for
I
EMS?
can't do nothing.
Yeah, EMS is on their way.
Okay.
My face is gone.
Well, do you want to hobble at this point then?
I
hold
can't
on to
breathe,
EMS.
man. Please.
Would
Please let me stand.
hobble in the sergeant's
Please, man, I can't breathe.
So you see there, they're talking about that hobble restraint, which would have used a strap instead of the officers having to be on top of his body. And Officer Tao saying, no, a sergeant would have to come out and file a report in that incident. So the state saying that this is relevant information that they should be able to get in front of a jury.
Ecleynne Mercy, bottom line is if they switch restraints here, George Floyd likely doesn't die. Is this effective in terms of, because one of the things with Tou Thao, he's just standing there, right? So you're thinking, how are you ever going to get a conviction with this dude? He's just literally standing here. This seems like a very intelligent way to get a conviction, and it is relevant. Do they get that information in, though?
Yeah, I mean, if they make it relevant, the simple fact that falsifying records and manipulating witnesses or intimidating witnesses are crimes that he committed while on the force, while on the job. So these crimes are, considered his moral turpitude. So because it's considering his moral turpitude, his character for truthfulness, I do believe that it'll be in. It gets in.
All right, Julia, next point, talking about Derek Chauvin.
Right, we already had an offer of evidence that the state had filed back September 10th saying that they intended to list all of these different former arrests of Derek Chauvin that show his knee on the neck of different assailants and how he operated. We now know how they plan to try and get that in, that they are going to use the fact that this shows his intent, his knowledge, and his mode of operation, modus operandi. And there's one of the incidents that we previously have let our viewers know about, and that's one that happened in 2015 where Officer Chauvin was arresting a intoxicated and mentally disturbed male, and that the other officers that were there with him put him in a side recovery position. Those officers were eventually hailed for saving that man's life because they put him in the side recovery position, something that did not happen when George Floyd was being arrested, even though one of the officers on the scene, Thomas Lane, did ask about putting him on his side.
Joe Tamburini, that this is your neck of the woods here up in Minneapolis. What's your take on the prosecution bringing this up as an MO? Could the defense use it and say, yeah, it's his MO and no one else has ever died? And George Floyd died because he had drugs in his system. Do you think that could be a double-edged sword here if it comes in?
Absolutely. What they're trying to do is what's called prior bad act evidence, 403B evidence in Minnesota. And in order to do that, you have to prove by clear and convincing evidence that it in fact happened and that it's relevant. But as you just said, if these things happened in the past and he wasn't charged with any crimes in the past for these, and all those people survived, I think the defense could use this as well. I think this prosecution is going to have a very hard time getting this evidence in because it's going to be very damaging to the defense and its relevance might be lower. And even if it does come in, like you said, I think it could be used as a double-edged sword saying, well, this was used before and no one was harmed.
All right, Mr. Prosecutor Adema, what do you think about these first two? The Tou Thao is lazy, and Chauvin has used this before.
I love this evidence for the prosecution, Ted. I mean, generally these prior bad acts evidence are things that prosecutors love. And I I got to tip my hat to the Minnesota Attorney General's office, Ellison and his staff, how they tried this case, how they charged it. They charged the felony murder there, so they kind of get around the intent for the first degree, but they can still get the murder in if they prove that Chauvin and Thao just had the intent to commit assaults. So how are they doing it? Obviously, Tao's a little bit tougher, but you, as a prosecutor, want to show that he's aiding and abetting by standing there because he's lazy. He's preventing other folks from getting involved, and he's actually listening to them saying, hey, you're going to kill this person, and he's doing nothing. So I like what they're doing with Thao. For Chauvin, obviously, his argument, and we know what his argument is because his defense attorneys have already said that he didn't intend to assault Floyd. So this evidence shows two things. One, no, you've assaulted folks in the past and you know better. You know when someone's cuffed, you are not supposed to put that kind of pressure on someone's neck or back. So I love what the prosecution is doing. I think the evidence comes in and it's going to be very damaging for the defendants in this case.
Ecleynne, there's training literature where it shows officers basically doing what Chauvin was doing. Isn't it a valid argument for Chauvin to say, this is what I was trained to do, this is what I did on many different occasions, and I didn't mean anything. I was just doing my job.
You have a duty to save. This man was calling out for air. He was calling out for help. He was in a distressed situation. If you didn't understand what he was going through, the many witnesses around you were able to tell you that he was choking, that he could not breathe, and you disregarded it. So at that moment, you disregarded it. Okay, I will take it for the minute 1 to 2, but 3, 4, 5, 6, 7, 8 whole minutes that you don't understand that you're an adult male and you have your whole knee on someone's neck, and that it's foreseeable that can cause death. So at that point, I don't believe that argument is going to pass the muster.
Julie Janae, we have heard from George Floyd's family from the beginning, but specifically his sister seems to keep the drumbeat going and really keeping his memory alive, and we saw that again this weekend.
Right, Bridget Floyd over the weekend responding to a case that has been connected a lot of times with her brother George Floyd's case, and that's the one of Breonna Taylor. So she is not only talking about her brother's memory, but responding to the news that the officers involved in Taylor's shooting death would not be charged. Take a listen.
My heart just really, really hurts for her family. It did spike something to where I thought about my brother again, and it's just really sad. His goal was to touch the world. That's something that he stated a couple of weeks before his death in a video, that he really, really wanted to touch the world. We had no idea that by him saying that, what happened was going to happen.
One of the other issues that this family has taken with how the defense has portrayed George Floyd is the prior bad acts they tried to get in about him, about the times that he was arrested in the past. That's something that the judge has denied back on September 11th, but now the judge still has to make a decision on whether or not these prior bad acts of the defendants will get in, Ted.
Yeah. All right, Julia Janae, thank you for your insights today and helping us guide this discussion. Joe Tamburino.
It's okay.
His sister said that he wanted to change the world. He wanted to touch the world. Obviously not this way, that anybody would want that to happen, but it's fair to say that he has not only touched the world, but specifically touched Minneapolis, St. Paul. What effect has this had on your community there up in Minneapolis?
Oh, it's had a huge effect. I mean, you can't even really comprehend how far-reaching it's gone. And one of the unfortunate things about it, it's had an effect where there's been a lot of damage to property and a lot of people who have been harmed since this time. It's a complete tragedy all the way around. But I would like to ask your prosecutor a question about when he said about the prosecution of this case. Recall that what the charges are, from a defense perspective, just looking at the charges, it is felony murder. So therefore, you have to have an underlying felony. The only underlying felony that this case could have is what's called third-degree assault, substantial bodily harm. And the medical examiner's evidence, as we know in public record, has said that there was no substantial bodily harm done to the physical neck of Mr. Floyd. So I think from the defense perspective, that's what they're going to focus on. And I think it's going to be tough on the prosecution side to show what's called substantial bodily harm as the underlying felony.
Nima, what do you say?
Well, I know that the Floyd family has done their own autopsy with their own examiner, and I know the medical causation is going to be challenged here, whether it's the drugs, but in my mind, there's absolutely no doubt the cause of death. Obviously, I'm not a doctor, but that's plain for every single juror to see. And going back to the handbook that's been misconstrued by the defense there, yeah, there's a picture of an officer with his knee on someone's upper back, but the plain text says when someone is in cuffs, you release that pressure. You call emergency medical services. So, when I hear defense counsel trying to use that image as some sort of get out of jail free card, that's absolutely not the correct reading. I mean, it's plain to see what you're supposed to do here and what Chauvin did not do. So if he's going to go argue that his knee was not the cause of death, that is something I would take every single day as a prosecutor to the jury.
All right. We shall see, obviously, a case that we are watching very closely. We're going to step aside, take a break, and when we come back, another case we're watching out of Colorado. Stay with us. On the docket tonight, a case we're watching out of Colorado. 13-year-old Dylan Redwine went missing in November of 2012. His body was found 7 months later. 4 years after that, his father was arrested and charged with his murder. Here's more from our affiliate, KMGH.
Betsy Horvath has long believed Mark Redwine killed his son Dylan.
Absolutely.
Why do you say that?
Because it is violent.
She too was involved in a custody dispute with him. They had 2 kids together. According to this indictment, he told Horvath that he would kill the kids before he let her have them.
I didn't let him have the kids.
Mark Redwine was arrested more than 4.5 years after his son Dylan disappeared. The 13-year-old was last seen alive November 2012 during a court-ordered visit with his dad. The following year, some of his remains were found just 8 miles from his father's home. At the time, Mr. Redwine told Denver 7 by phone he wanted to know where Dylan's remains were found so he could be close to his son.
It's hard for them to describe to me the exact location that they found these remains. I've asked members of law enforcement to stop by, and I want to talk to them about going to the location so I could be close to my son.
But the indictment reveals a subsequent search found Dylan's blood in multiple locations at Mark's home. A police dog detected a cadaver scent in Redwine's living room and his washing machine. Dylan's skull was found in November of 2015, just 1.5 miles away. It had injuries consistent with blunt force trauma.
My greatest hope is that Dylan gets justice.
Betsy Horvath says the arrest is just the beginning of a long road ahead, and her heart breaks for Dylan's mom and brother.
The scariest part is it could have been my child.
All right, this is a case we're watching out of Colorado, and it is an interesting one because of the time between the first disappearance and then the recovery of little Dylan's body and then the arrest. 4.5 years went by before Dad was arrested. Think Tank still with me, Ecleynne Mercy, Joe Tamburino, and Nima Rahmani. Let's start, Ecleynne, with you. The 4.5 years, that's good for the defense, is it not? If you're saying, hey, you want this guy convicted beyond a reasonable doubt, and it took them 4.5 years to figure this thing out?
Absolutely. That, because usually the parents are the first to be suspects. So obviously you didn't have enough information for 4 whole years, or did it take four whole years for you to build a case? So as a defense attorney, I'm jumping all over that. And the fact that he was just asking to, be around the area, which is weird, but you can absolutely use it for your defense.
People acting weird in situations like this, Joe, you shouldn't judge, right? But don't juries look at actions by a defendant and think the worst usually, and it goes with that narrative that the prosecution is laying out there?
Yes, many times. I mean, I've had many trials, and one of the biggest things is, how is your client acting? Is your client acting guilty? Is he acting like he's hiding something? Is he acting non-empathetic? They watch them constantly. I think this is a hard case on both sides, but think about it this way with the prosecutor. Besides the blood, which there could be explanations for the blood, and obviously those, the words that the defendant said about that he would kill the kids, that's not good for the defense. But it took 4.5 years. They don't have a clear motive other than the blood and that cadaver scent. And again, when was that cadaver scent? Could have been caused by anything other than obviously this child. I think it's going to be a tough road for the prosecutor. But yeah, to answer your question, of course, they're always watching the defendant.
Nima, as a prosecutor, when you have a case like this, clearly the prosecutors there think he did it. They likely thought it after day one, but it took 4.5 years for them to pull the trigger. What barrier there is? What happens in the 4.5-year gap? What do you think it's just that they were looking for one extra piece of evidence, or maybe a change in opinion? Someone didn't want to go, and then that person maybe isn't in the office anymore. What goes on typically when you have a delay like this?
Yeah, I mean, these are political decisions made by folks running for office, especially when you have a high-profile case like this. So here you have a father accused of murdering his child. I think over time the case got better, right? You found the skull and you found those remains. You have these really sort of bad admissions, one of which was made to Dylan's half-brother, saying that without the remains, the skull, the prosecution doesn't have a case. Well, that's pretty terrible for the defense, right? You have the ex-wife, the original ex-wife, that's come out and said that he would have killed the kids rather than give them up in custody. So over time, the case did get better for the prosecution. You have obviously, you have your motive here. Dylan had the compromising photos of his father wearing women's clothing or in diapers or eating feces and all sorts of sort of weird behavior on the part of the defendant. He had the opportunity. Dylan was in his custody at the time, and really his defense in the case was that he took off to his friend's house, which was approximately 6 miles away. So I still like this case for the prosecution, even though it took some time for us to get to where we are.
The high-profile nature, Ecleynne, does it add something to this when you do get in front of a jury, that pressure to possibly come back with a conviction? Does that work in the prosecution's favor, do you think?
I mean, it can go either way. It all depends on how your defendant acts. Like Joe stated, yes, what your defendant does matter. So if he's gonna click crazy, then of course you have a problem because of the high profile. But if he is going in there like a really, just mournful father, it can actually help and be to his advantage.
All right, we're watching this one. This is on the Court TV docket because it is a case that we will show you most likely live here. And this is the way it is scheduled out right now. There is a pretrial conference October 8th, and then there is a trial date October 28th, and we have seen a lot of these get continued to 2021. But in this case, the judge, the prosecutors, they really do want to hit this October 28th. We're seeing courtrooms come back to life, so who knows? We'll find out more at the beginning of October. We're going to step aside, take a break. 13th juror is next. Okay, welcome back. We have seen that video, of course, before. That's Jacob Blake getting into his vehicle. He is shot 7 times in the back by an officer in Kenosha, Wisconsin. Well, there's a development here in that the officer, through an attorney, is explaining his actions. CNN reporting that the attorney representing that officer, Rustin Shesky, the attorney's name is Brendan Matthews. Matthews tells CNN that Shesky says that the reason that he discharged his weapon 7 times into Jacob Blake's back was because he was concerned that there were children in the car, and specifically in the back seat, that he thought that Blake was going to kidnap one of the children in the back seat, take off basically with these kids in the back seat. So that's our 13th juror question. What do you think about this explanation through the attorney of Officer Rustin Shesky? Our first comment, the comment of the day, comes from Joan Cooper. Sounds like another officer obfuscation to me. I'm sure the police union helped to spin the story in the officer's favor. This is the same police department that let an armed white 17-year-old walk right past them after he murdered 2 people. If Kyle was black, he would have been dead now. Talking about Kyle Rittenhouse, of course, there, part of this same area in Kenosha. Ecleynne Mercy, what's your take on this? This viewer says, oh, give me a break. What do you think?
Yes, Joan, give me a break. Come on, he was. So you're going to change your story. I don't like when cases involving law enforcement, they're trying to try their case in public opinion. It's already bad as it is. The climate is already not suitable for that. And I don't like, especially with officers trying to try their cases in court of public opinion. It shouldn't have happened. And the fact that you have time to develop this theory about a phone call when the call was for family trouble. So you should have known that it was going to be a domestic dispute, and how you go about domestic disputes are different than the aggravated assault or anything like that. So I don't want to hear it. I'm with Joan. With Joan.
Next comment comes from Donna Morton. Donna says, we'll only be able to tell if he had a knife in his hand only when and if the body cam was on and if it gets released. There is more to this story than people realize. It's not always cut and dry. Joe, your thoughts on that? Usually that's correct. It isn't always cut and dry. There's more to every story. What do you think?
Yes, there's always more to every story, but in this case, they don't have the body cam because I don't believe the officers were required to wear body cams.
That's true.
And that's something that you just got to change all the way around. I mean, in today's world, it doesn't take much to get the equipment to have a body camera. They're small. You can put them right on your vest. This has got to happen because everyone needs transparency in what they're doing, and this would really help. But there is another side to the story. This is just one of the things that the officer's saying. We have no idea as this investigation goes on. Could there be anything about weapons in the vehicle, weapons on the victim? We have no idea. But, it transpires.
Jeremy says, I think the new development is nothing major. Changes very little. Nima, it's a first look at the possible defense here, his story, and that will be key. Law enforcement gets a break with many jurors, and if a cop gets up on the stand and says, this is what I was thinking, it's a different witness, is it not, than a lay witness?
Of course, even though the law says that law enforcement is supposed to be treated just like any other witness, we know that's not the case. Jurors love police officers. And you see the shifting defense strategy in this case because, you have a police officer who killed Blake execution style 7 times in the back. So
didn't actually kill him, but paralyzed him.
Oh yeah, paralyzed him. Sorry, excuse me. Paralyzed him from the waist down. That's absolutely right. Sorry about that. Thanks for catching that, Ted. Okay, paralyzes him from the waist down, right? So the first argument was that Blake had a knife in his hand. Well, don't think so, right? Because then the knife was on the floorboard of the vehicle. But what's better than a self-defense argument? You're actually there protecting the kids. So now we have an entirely new argument. It's a better argument, much better than the self-defense one, but you see how defense attorneys will always kind of shift the story and shift the paradigm to protect their client. So of the 3 stories, it's the best, but I'm not going to buy it if I'm a juror in this case.
Yeah, there for the kids. It always works. Jerry says, yes, he would have taken off and kidnapped the children, possibly killing them, and then the officers would have been held liable for the children's death. The officers saved the children and shot Blake in the lower torso. Non-lethal. Good job. Ecleynne, I hate to give this one to you because I know what you're going to say, but go ahead and say it.
I'm done because Kyle Rittenhouse walked in there with the AK-47 and basically gave a high five and was able to make it home to his bed that evening. So that idea that, because it's a black suspect, he's going to go and chop up little children. No, that was the case beforehand. He was just merely trying to get into the car. So I'm not buying it. Do better.
All right. That's what I thought you'd say. Next one is from She, and it's the officer fired a gun in a car full of kids with 3 mad faces with bad words written on the faces. Joe, good point, right? If he's concerned about the kids, he's willy-nilly firing 7 times into the car with kids.
Oh, it's an excellent point. I mean, if these officers are charged, and we don't know that yet, I mean, compare this to other investigations. This is going to take some time. They're not just going to immediately charge everybody. They're going to have an investigation. But if these officers are eventually charged, those kids in the vehicle change everything. It just puts a different spin on everything because, of course, you can't be firing a weapon within basically close earshot to young kids. There's other things that could have been done.
Okay, next one comes from Makisa Jones. So, will the charge for this officer, since there were children in the car, will it be the same as Mr. Hankinson? Wanton endangerment in the first degree. Is that how they're going to spin this one? What a joke. Nima?
Well, that won't be the charge in this case, right? Because that's an entirely different case, different circumstances. There's certainly less lethal or potentially lethal actions that these officers could have taken involving the tires or extremities. Again, when you're shooting someone's torso, you are shooting to kill, even though that's not what happened here. It could have easily happened, and Blake is going to be suffering for the rest of his life.
Absolutely. All right. I want to thank everybody who submitted something on the 13th juror and the panel. Fantastic as always. And thank you for watching. You're watching Court TV, your front row seat to justice. We'll be back tomorrow.